permits. The leadership, if the council seeks permission to continue with the facts of the case.
Yes, continue.
Much obliged, Your Ladyship. Your Ladyship, the present petition is filed by a Live Healthy Foundation, in which addresses the concerns about the environmental degradation caused by the hazardous industrial activities and the illegal mining activities which are being carried in the country. Your Ladyship, in this petition, two such incidents have been brought. The first incident, which occurs on July 9, 2023, wherein a hazardous gas, phosphorin gas, leaks from the chemical manufacturing unit of XYZ unit industries, which exposes the failure of the industry to follow the safety protocols. And another such incident occurs in the state of Uttarakhand, wherein the illegal limestone mining activities carried out by the Rustam Corporation Private Limited, it causes deforestation, soil erosion, and the disruption of water resources, and also threatens the livelihood of the local community. The ladyship, both the incidents have caused public outcry, large-scale public outcry, and brought legal actions, and which have highlighted uh, the failure of the regulatory bodies, such as the Central Pollution Board and the Ministry of Environment, Forest and Climate Change. The petition seeks and stresses upon the enforcement of stricter regulations in regards to the environmental safety key concerns. The leadership, the council asks permissions to further continue with the arguments.
Granted.
Much obliged, your ladyship. The ladyship, the first issue who deals with whether the writ petition under Article 32 of the Constitution is maintainable in the present petition. The ladyship, the present petition, the council submits that the present petition is maintainable under Article 32 as it raises the concerns about the violation of fundamental rights as guaranteed under the Constitution, particularly to the right to clean environment and a healthy environment as enshrined under Article 21 and of the Constitution. The leadership, the activities carried out by the XYZ industries and the Rustam corporations and are in the are under the ambit of other authorities and are under Article 12 as they perform both a governmental and a private function and and can be brought under the ambit of Article 32 as held in the Ajay Hasia versus Khalid Mujabi, which proves which establishes uh, the principle of whether when a private entity can be brought under a PIL, a public litigation interest. The ladyship, the RCP Corporation being a private entity can still be brought under the ambit of Article 32 as was recognized in the case of Indian Council for Enviro Legal Action versus Union of India, wherein in it the judgment of the case said establishes that a private entity can be brought under the ambit of Article 32 if the state has also made a co-party in the petition. Ladyship, the risk jurisdiction under Article 32 can be invoked in the case even if using the doctrine of reasonable apprehension, even if there is even a threat to the fundamental right, it's as enshrined under the Constitution, and not just the actual violation, but in the present petition, as the right to life if is being violated in the present petition, this can be said that using the doctrine of reasonable apprehension, there has been an actual breach, not just a threat to the breach. So the breach of the fundamental right is prima facie established under this petition. Then the petition also argues about the violation of rights under Article 19 and Article 21. Your Ladyship, if the bench has no further questions about the issue one.
Before moving on to the next issue, I just want to know why have you clubbed these two issues? Don't you think that these two issues should have been filed in separate petitions and should not have been clubbed together because these are two different matters?
Your Ladyship, the matters being different occurred at in the same period, yet closely, and have led to a huge outcry, as mentioned in the arguments. It led to a huge outcry in the country.
I understand that they have led to outcry. It's a serious issue, but don't you think both of them are not at all related? They have not occurred at the same place. They are not related in any way. One is talking about illegal mining activity, and the other incident is talking about a gas leak in any industry. So, don't you think, as per my opinion, it should have been two separate petitions and should not have been clubbed in a same petition?
Your Ladyship, both these situations and incidents have relate to a serious environmental safety concerns. As in both the situations, there has been a violation of the rights of the people in under Article 21, and in the under Article 19, the right of the corporations themselves to carry out free trade and operations in the country can be brought into question.
We have different views with respect to this, but as per my opinion, I suggest you that it should not have been clubbed together. Carrying on, move forward.
Leadership. The leadership, the council seeks permission to continue with issue number two. Leadership, the issue number two deals with the implementation, whether the implementation of the policy of the government is violative of Article 21 and the rule of law. Your Ladyship, the petitioner humbly claims that the government's action are violative of Article 21, which guarantees more than mere existence for survival, but also a right to live with dignity as established in Maneka Gandhi versus Union of India. In this case, in this present petition, the right to live with dignity is being violated as the people in both the states have been affected severely, not just mentally but also physically. The health of the population is being raised, yes, and is being violated in the present petition. The project, the permission granted by the government and to continue with the mining projects and the continue of operations of the such hazardous industries in a residential area risk human life and also raises concern of environmental safety, thus violating the principle of rule of law. The government's policy decision established it should pass an equality test under Article 14 and a test of reasonable under Article 19(1)(g). The corporation's activity under Article 21 is being the corporation has violated Article 21 due to the inherent risky nature of the operations, which would in turn and put a reasonable restriction on Article 19 plus clause 1 subclause G, which provides the corporation to carry out free trade. So a reasonable restriction can be put on the activities of the corporation and the industries involved in the present petition. Ladyship. Ladyship, if the bench has no further question, can the council seeks permission to move forward with issue number 3?
Yes.
Ladyship, the issue number 3 deals with the applicability of absolute liability doctrine and the polluter pays and the precautionary principle established by the law. Your Ladyship, the doctrine of the absolute liability established in MC Mehta versus Union of India, wherein the court established that the the polluter of the environment or the hazardous industries is must bear the complete responsibility in case of the harms caused due to their activities, with no exception. This doctrine is broader in respect with the strict liability doctrine as established in Ryland versus Fletcher, uh, due to the hazardous nature and the risky nature of the operations of the industries and the illegal mining activities. The environmental impact, the environmental impact has to be considered under this doctrine, which would in turn make it applicable on these industries. Please, Your Ladyship, the polluter pays principle also mandates that the polluting industries must compensate for the damages caused, and the precautionary principle requires the government to take preventive measures to avoid the environmental harm, both of which were not done by the government. And to, as the government failed to provide any such necessary regulation, and that would have put limitation on the mining activities of the corporation and the operation of the XIZ industries in the present petition. Your Ladyship,
You're
sorry,
talking about the MC Mehta case here, which
yes,
introduced the principle of absolute liability. This same case introduced another principle. So have you read the judgment?
Ladyship, I cannot recall the particular judgment as in full due to the limitation of the human mind.
So I'll suggest you to read deep pocket theory, which was introduced in this judgment. I think that would also have been in favor of your petition, where the court said that the deeper the pocket of the industry will be, the heavier fine will be imposed on those industries if they are causing any harm to any person or environmental harm or any property or anything like that. So that would have been in your favor. You could have mentioned that.
Apologies, Ladyship.
Always write Supreme Court in capital letters. That is a very basic blunder, but it immediately catches your eye. Sorry,
Sorry,
continue.
apologies, Ladyship. Ladyship, the council seeks permission to further continue with the issue 4.
Granted. Continue.
Lady- Ladyship, the issue 4 deals with whether the environmental clearance given by the government is valid or not. Ladyship, the petition argues that the environmental clearance by the government to the RCP Limited Corporation is invalid due to the non-compliance of the environmental impact assessment notification of 2006. The RCP Corporation to failed to oblige to the uh, test of the scope of the regulation in which it was said that at the corporation asking for a mining operation in a particular area must seek public consideration and public appraisal, and must apply for a scoping of the area which is in the question, both of which was not done by the corporation involved, or as they have established their industries is in the residential areas of the towns or the cities. The the non-compliance also is in violation of the Environmental Protection Act of 1986 and the Forest Conservation Act of 1980s. In the Odisha Mining Corporation versus Union of India, Ministry of Environment and Forest Climate Change, and it was held that there should be a restriction on the mining leases granted on the area in the area, making the clearance legally unattainable. As in this case, no scoping of the area was done. There has been no mention of how much area of the query was, and they have failed to procure any legal backing other than the environmental clearance given by the ministry, which would in turn and expose the failure of the regulatory bodies. Uh, Ladyship, if the bench allows, I would like to continue with my prayer. Much obliged, Your Ladyship. Your Ladyship, in light of the issue raised, the argument advanced, and the authority cited, may these may this honourable court be pleased to firstly quash the impungent environmental clearance. Second, to issue a prohibitory order restraining the respondents from proceeding with the mining project. Third, direct the respondent to pay the compensation to the victims of the quarry incident and the gas leak incident in both the states. Appoint a high-level expert committee, which would in turn put a regulation on these industries, is which would periodically be answerable to this honorable court. Fifth, if order the closure or strict regulation of such industries which are hazardous and mining activities that pose a significant threat to the public health and the environment until adequate safety measures are being implemented, and pass any such order, writ, or direction that this honorable court deems proper and fit. For this petitioner shall be duty bound. Pray.
Okay, so I have two suggestions for you. Firstly, there are a lot of issues with the formatting of this document. Line spacing. If I talk about how the sentences are framed, a lot of grammatical errors. If we are talking about a statute and when we write the term act, it should always begin with a capital A, because if we write it with a small a, the meaning of that changes. That means conduct. So formatting issues, grammatical issues, line spacing is about basic cheezeं होती है, but that elevates your document. Also, the issues could have been better framed. These are just suggestions for you to incorporate in your next competition. The issues could have been better framed. These issues are not very clear about what they want to suggest to the person who's listening to these issues or reading these issues. And one of the major suggestions which I gave you in the beginning only, that these two instances should not have been clubbed together and should have been dealt separately. Sure. That's it.
AC32, you may leave the meeting.
Okay. Thank you, sir.
Resulted in the violation of fundamental right, a right guaranteed under Article 21A and 14 of the Indian Constitution, that is right to equality and right to education. So, first of all, at the outset, the council would like to address the maintainability of the PIL, which is from the petitioner under Article 32, that the petitioner have necessary locus standi on the to approach the court on behalf of the affected student, as in the case of Bandhwa Mukti Morcha versus Union of India, the court
briefly mention the facts of this petition. Can you briefly mention the facts?
Indeed, Your Lordship. The facts of this case law is just like that. ITA is the ITA, that is Indian Testing Agency, is an autonomous body which works under the executive body of the Indian Constitution, and it is liable for conducting various examinations. And in that examination, one of the examination is IMCAT examination. So these examination is conducting in various and in every year, and for that more than 18 lakh students is going for that examination. But there are various instances has been occurred in which IMCAT failed in conducting proper examination, that lead to a violation of the fundamental rights of the students. So these students have come with a form a group and filed a petition under Article 32 of the Indian Constitution. If the Lordship is well versed with the facts, Council wants to move further.
Yeah.
Okay, indeed. Furthermore, the concept of locus standi has been evolved in Bandha Mukti Morcha versus Union of India, that in which the court evolved that public law. The petitions filed by the public spirited individual and association can be also uh, uh, accepted in the court of law. And here with the help of and here in this present case the same thing is also happening due to the socio-economic disadvantage and the lack of resources of many students who are not liable to not who are not able to file the case differently in a different court. So they form a group and file in under one PIL. And also uh, under the memorial it is also mentioned the report of National Institute of Health by the SKCAR 2020 report. It is also mentioned that due to these kinds of failure, due to these kinds of paper leaks caused a psychological and the academic setback to every student, that caused severe mental health issues including societal tendencies that is a kind of liability for the state. Moving further with the violation of Article 14, the right to equality is a cornerstone of our constitution. The ITA failure to prevent paper leak in IMCAT examination constitute the violation of violation of this right. Also, uh, in the case of Menka Gandhi versus Union of India, it is the expansion of interpretation of Article 14 Article 14 has been made, in which it is expanded. It is meant that the violation of the violation of Article 14, 19, and 21 will be dealt with under Article 32 of the Indian Constitution. Moving further with the Article 21, that is the right. Article 21A has been infringed. Article 21A is a compulsory education for children. But in a case of Unni Krishna versus State of Andhra Pradesh, the scope has been expanded to the right to education as an essential component of a right to life under Article 20. The ITA's here in the case of ITA's failure to conduct the fair examination and professional development by compromising the merit-based selection process, the ITA has denied students their right to education and a right that must be safeguarded to ensure equal access to opportunity. As here, only a group of students have been uh, advantage by the paper leak as they got the paper before the examination, while on the other students who are not able to get the paper and have and are not advantage. So here is a uh, uh, clear violation of Article 14 and Article 21A of the Indian Constitution, as the failure of one institute caused the uh, cause these kinds of issue in the national in the Indian context. Uh, Going for the council number two, the issue of going for the council number two.
If we talk about Article 21 clause, Article 21 capital A, it does not talk about giving education to each and every student in our country. It talks about a specific set of people.
Your lordship, in a Mohini Jain versus state of Karnataka, the court stated that the right to education doesn't mean to give the proper right to education doesn't mean that every education given to in the current case. Uh, right to education has been taken away from the student in a simple manner, where giving paper prior to the examination, causing few of the students who are not liable to get that examination institute, and those students who has done hard work to get that exam that institute for their further studies are not able to get that exam that institute, and this is a clear violation of Article 21A.
Continue.
Okay, my now my co-counsel number two will deal with the issue number two. Thank you. Council number 2, your mic is off.
Good, good afternoon, everyone. Uh, I am the council number 2. Your Honor, I am representing this PIL over to you for critical national importance. We are here to address the gross negligence of the Indian Testing Agency (ITA) in conducting the 2024 Indian Medical College admission test, where the failure to prevent a paper leak has led to several consequences. This failure has not only violated the fundamental right of the student but also resulted in significant economical and environmental damage. We seek this court intervention to ensure accountability and introduce essential reform for a secure and sustainable examination process. Violation of students' fundamental right, your honorship, the cornerstone of the legal framework is the right to equality under Article 14 of our Constitution. This guarantees that every individual treated equally before the law. In context of the competitive examination uh, of IMCAT, this right translates into providing all students with an equal opportunity to compete on fair ground. But the 2024 paper leak has undermined this principle, offering an unfair advantage to students who had access leaked paper with those who have diligently were left at a severe disadvantage. Some of the students are prepared very well, but they have no any access to the leak paper, and they due to the paper leak, and they are at the list. They are suffer, but the student who got leak paper, they are at the advantage level because they get the leak paper and they know the questions and so they are very at advantage level, and the student who are uh, prepared very well are not at advantage level, and because they did get the paper leaked, and also this lead to the lot of issues, like they have mental issues, and this creates a system of arbitrariness where merit is overshadowed malpractices. The student who gain admission through elect means may struggle academically, while those deserving admission face mental stress, loss of confidence, and fundamental breach of trust in the system. Furthermore, the cancellation of the examination due to the leak only aggravates the anxiety to a student who must retake the test, causing additionally emotional and psychological strain. Uh, this and also some economic loss occur. Your Honor, ITA negligence has led to a substantial economic losses, not only affecting student but also the state. Uh, like conduct like IMCAT require the allocation of vast public resources for logistics, security, personnel, and infrastructure. When the exam is compromised, as it was in this case, these resources are wasted and the public suffers significant financial losses. The costs are not limited to conducting re-examination. They also extend to the legal proceeding and the investigation required to identify the hold those responsible accountable. This clear violation public accountability as recognized in Common Cause versus Union of India. That if failure directly burden taxpayer further eroding public trust in national institutions. Environmental, Your Lordship, while the economic and the right-based implication are significant, we must also address the environmental consequence of ITF failure. The IMCT exam involved the mass production of printed question paper across the country, which are printed, and when they are printed, lot of resources uh, are being used, and when the lot of resources are being used, then lot of trees are cut down for this for making paper. A lot of the trees are cut down, so this lead to the environmental loss. The petitioners submit the ecological impact of such large-scale examination, especially when compromise cannot be ignored. The production of paper contribute to the destruction of water consumption also and carbon emission. Judicial intervention is needed to encourage the ITA to explore more sustainable alternatives such as the adoption of digital exams or regionalized question paper. Judicial oversight and reform. Your Lordship, the failure of
decision making. In the case AK Karaipa versus Union of India, this case emphasized that no administrative action can be immune from judicial review. Yet, the absence of a clear and accessible appellate process in media censorship prevents content creators from challenging unjust decisions. Finally, your ladyship, unchecked executive powers in censorship leads to serious overreach to prevent abuse of executive powers. This undermines the rule of law and violates the principle of natural justice that this court has long upheld. Your ladyship, now my co-counsel will be dealing with the second issue.
If your ladyship is satisfied with the pleading submitted by in the first and third issue, the council seeks permission to begin with the pleading of the second issue. Much obliged, Your Lordship. The second issue before us is whether the Cinematographic Act 1952 is granting excessive discretionary powers to government and violating the public rights of information. Your Lordship, it's a crucial and expansive issue discretionary regarding the comfort of the Central Board of Film Certification and the Ministry of Information and the Broadcasting under the Cinematographic Act 1952. Specifically, the Section 4 empowers the CBFC to examine and certify films, allowing to certify movies and films regarding the submission of the weight criteria. Meanwhile, the Section 5B enables the CBFC and the MIB to impose restrictions on film and to deem violate the public order, decency, or morality. However, these terms are not explicitly defined under the Act, resulting in the lack of clarity and leaving significant room for the arbitration. The ambiguity inherent with the provisions permitted by the CBFC and the MIB exercise unchecked discretions, leading to potential misuse of the power, as highlighted by the court in K.A. Abbas versus Union of India. Any restrictions on free of speech must be grounded in clear, specific standard, which in the Cinematographic Act fails to provide for the same. Consequently, the broad discretion often results in arbitrary decision making that undermines the fundamental right to the free of expression. Also, the principal necessity of proportionality emphasizes in S. Ragarajan versus P. Jagjeevan Ram was frequently disregarded. The Great criteria was also outlined in the Act enable for the disproportionate restrictions and the hindrance of the public access to the diverse viewpoint and infringing upon the rights of the receiving information. Unfortunately, the excessive discretionary power granted under the Cinematographic Act often results in the suppression as well as the addressing of the crucial societal issues and the dissenting viewpoints. The banning of the documentary India's Daughter, which highlights the significant societal concern surrounding the gender violence, exemplifies how these powers can obstruct public access to a vital information. Such censorships not only deny citizens the opportunity to engage in meaningful discourse, but also to stifle the importance of the conversation above the pressing of the national issues. Now, if your lordship is satisfied with the pleading submitting in the second issue, the counsel seek permission to begin with the prayer. Your Honorable Court, in the light of the fact presented in the argument advanced, we respectfully request this Honorable Court to declare any censorship or undue restrictions imposed by the respondent exceeding the bound of Article 19, Clause 2 of the Constitution of India unconstitutional and violating the Article 19, Clause 1, Subclause A. For the further, we seek the court's guidance for formulating comprehensive guidelines in ensuring any regulation of the media content and government body for this reasonable and transparent. Additionally, we urge for the establishment of the important Media Freedom Oversight Committee to monitor and review the censorship action. We also pray that the implementation of the safeguard is to protect the media organization from arbitrary censorship and legal actions. Finally, we request the Honorable Court to grant us any other relief deemed to appropriate the interests of justice, equity, and good conscience, all of which mostly humbly prayed. Ma'am, you're not audible.
Am I audible now?
Yes, ma'am.
So I have a few questions in mind right now. First of all, you're talking about the absence of any appellate body regarding where to take the appeal if you're not satisfied with the decision of the board. As far as I read the Cinematograph Act yesterday, and I think section 5 clause C or 5 clause D of the act talks about creation of an appellate tribunal. So have you read it? Because there already exists an appellate body. You are pleading the need of creation of an appellate body, but on the other hand, we already have an appellate body which functions in New Delhi. Am I audible to you guys?
Yes, yes, your ladyship.
So kindly check it, read it, and accordingly make a few changes in your petition. Also, in your petition, you're talking that once the CBFC gives a decision, there is no process for a fair hearing or take up your grievances with the board. But if you check the website of the CBFC, as soon as the CBFC gives a decision, some time is given to the other party where they can take up their grievances to the board. So if you check the website of CBFC, I just checked it yesterday and it was clearly available there that if you're not satisfied with the decision of the CBFC, you can go and talk to them, you can present your own reasonings, and in case even after that your reasonings are not heard or are not considered appropriate by the board, then you can approach the appellate body for your matter. Am I audible? Am I audible here?
Yes, yes.
Okay.
Yeah.
Another thing, you're talking about this ambiguous criteria of public order and morality, where you're talking about mentioning how to deal with this term of public order and morality. But don't you think that this whole concept of public order and morality is a very dynamic concept, and it is very difficult, really difficult to set a framework with respect to that particular term? Because if we talk about morality, you guys must also be knowing that morality cannot be confined to these specific boundaries. It changes with time, it changes with society. We have many examples with respect to how morality has changed with time. So don't you think the government has done a good job by simply using the term public order and morality and left it to the discretion of the board that according to the present scenario and present circumstances, you decide on the basis of your own wisdom that what will be the public morality in the current scenario and what will be the public order in the current scenario?
Yes, Your Lordship.
If you do not agree to this, you can also counter me.
Your Lordship, you're right.
Team 24, I cannot hear you.
Yes, Your Lordship.
Like your lordship, there is in that particular act, it is not particularly defined what is public morality or public order or public morality. So how can we like
Found it.
matlab like how
My co-counsel wants to say that how can we define that in a specific order that what is public order or what is public morality? Like in certain aspects where the movies or some movies depicts how the patriarchal society works and how uh, people should work in a manner, how can you define that it is right for this time period? Like if we talk about the movie like Animal, the movie confers how the violence occur and a man can do whatever he wants to, how he kill people, but in the same manner how the BBC documentary of India's Daughter was banned in India because it showcased how the rapist mindset works. So how can it be shown that the public morality has conferred in from time to time, and how can we say that it is it is existing, and how we can understand what is public moral and what is decency in over the time period.
Okay.
ma'am, your ladyship, in that particular case, Viacom 18 Media Private Limited versus Union of India, the issue was the film Padmavat, like originally Padmavati, faced violent protests and ban from several states due to its like portrayal of historical characteristics, despite receiving clearance from the CBFC. The ruling of the Supreme Court was once a film is certified by the CBFC, states cannot impose bans unless there is tangible threat to public order. So, like here, there is no definition of public order. There is a government censorship or the arbitrary or discretionary powers that government is imposing. Uh, in this particular case, there is like it affirmed that freedom of speech and expression cannot be curtailed based on that on mere appearance of violence.
See, that's what I'm saying. It's very difficult to define if we talk about setting some guidelines or framework with respect to public order and morality. That is a difficult task to do, Herculean task to do. Not an easy thing to do because the parameters of public order and morality changes with time and changes with society. So just using that specific word and leaving it to the wisdom of the board is a correct thing to do because we have people sitting in the board at that point of time who can understand what is going on in the society, what time period we are living in, and accordingly make that decision that whether that particular matter should be or should not be censored as per the terms of public order and morality. That's it from my side.
Leadership.
Yes, Your Lordship.